Thanks for having me. Thanks for being here, everybody. Um, as you heard, I am the managing principal of Friedman, Framme Thrush. We're a full-service law firm located in Owings Mills, Maryland, with a regional presence in Maryland, D.C., and Virginia. We've got an office in Richmond as well. And we do a bunch of stuff, but as Susan said, my practice focuses mainly on civil litigation, with a particular focus on creditors' rights. And creditors' rights really just means commercial litigation and debt collection, and other kinds of commercial types of cases. That's what we're going to talk about today. Strategies to help you minimize your business debt. Because ultimately, to be a successful entrepreneur, to be a successful small business, you really don't want to have to hire me. Um, you would really, and the whole purpose really of this presentation is to give you some strategies to avoid having to ever get to me. Let's dive right in to that. So this is me. That's a really old picture, as you can see. So we're going to break this down into three parts. We're going to talk about it in three different phases. The first phase is going to be before the customer relationship starts. The second phase is going to be after the customer relationship starts. And the third phase is going to be basically when things kind of come off the rails a little bit. As all good plans, let's begin at the beginning. Before you enter in, I think we have someone just posted something in the chat.
That was me.
Oh, that was you. Okay. I want to mention also, feel free to drop questions in the chat as you need, in real time, and we'll try to get to them as they come up. Don't worry about interrupting me. I'm happy to take questions as we go. So the first thing you're going to do is do your due diligence. And what that means is to basically know your customer, know who you're getting into business with, particularly if you're the kind of business that has to extend credit. That's where things go into trouble. And don't think of extending credit as just credit cards or credit accounts. If you have somebody that you're invoicing, in other words, you're not working on a retainer like attorneys do, you're extending credit. So if somebody's got, a pay on 30, pay on 60 relationship with you, you're floating them credit. You're giving them 30 to 60 days worth of credit because they're not paying for the goods or the services that you're delivering immediately when they receive them. So what do you want to do in your due diligence? There are a couple of things that you want to look at. First, you want to look at the status of the organization. That's really easy to find. Here in the state of Maryland, you can go to the State Department of Assessments and Taxation, SDAT. And I think it's sdat.gov or .org. I can't remember. But if you Google Maryland State Department of Assessment and Taxations or MDSDAT, it'll come up. It'll be the first one that comes up. And on that website, you can do a business search, a business license search. You can find out if the business that you're getting ready to deal with has a license, if they're an incorporated business or whether they're an LLC, whether that's in good standing, things like that. All of that's going to be important because if the relationship goes sideways, you're going to need to know who to go after to get yourself paid. Number two on the list is credit worthiness. Now, credit worthiness can be a little trickier than looking something up at SDAP. There's a company called Dun and Bradstreet. Dun and Bradstreet runs credit reports for businesses. Not all businesses have a Dun and Bradstreet report, so that might not bear any fruit for you. But if it's there, you certainly want to look at it. If you're going to be extending considerable amounts of credit to folks, you're going to look at number three, bank references. You definitely want to know who they bank with, and whether or not they have any issues with their banking portfolio. If people aren't willing to give you bank references, if you're floating them credit, it's a red flag as to whether or not you should do business with them. Number four is a less obvious option, and that's social media. Look at the company's social media presence. See what they're talking about. See what their customers are saying about them. See what other vendors are saying about them. But don't stop there. If you know who the principals of the business are, look at their personal social media accounts and see what they're posting. Are they posting hateful stuff on their personal site? Are they posting inappropriate stuff? All of these things are going to tell you who you're going to get into business with, and all those things are very important. And then finally, number five, a financial statement. Again, if you're floating credit to someone, it is not inappropriate. It is entirely appropriate for you to ask for a financial statement from the folks that you're going to be extending credit to. And if you're going to have people be personal guarantors on that credit, you're going to want personal financial statements from the principals as well. The next thing that you're going to want to do, and this is a big one because this is going to come up throughout this presentation, is that you're going to want to have a firm policy for receivables. Why do you want to do this? Well, the most important reason to do that is to set the expectation. It puts everybody on notice of how your accounts receivable are being handled. That way, when the customer gets into the relationship, they know exactly what's going to happen when and if they fail to pay on time. So what's the advantage of setting expectations early? Well, first and foremost, it minimizes the strain on the customer relationship, because when it goes sideways, and invariably they always do, something always goes sideways. So when it does go sideways, you can say, well, hey, look, it's our policy to do X. So we don't have a choice. Like, we have to do it. Realistically, you always have a choice, right? A policy is not a law, it's a policy. But if you create that policy, you create that expectation, it's not going to be a surprise to your customer. It's not going to take them back if they hear you enforcing that policy. Also, it makes it easier to turn over to someone like me if you can't get them to pay, because you can always fall back on the old adage, it's not personal, this is business, right? And if your policy is very clearly stated that that's what you have to do, then, I'm sorry, it's not personal, it's business. And that's important because particularly when we're talking about relationships, you become friendly with the people that you do business with. So we have Susan, I think we have a question. We have a raised hand. I'm not really sure.
Yes, Bill.
Handle
That's
that.
okay. That's okay, Bill. The question I have is, where would you place that policy if you have a like contract agreement or set of agreements? Is that something you place like up front, or is it something you place it on your invoice? Where
Yeah,
would you
both.
place that?
You place it everywhere you possibly can. You put it in the initial contract that your customer has where you sign them up, and I would put it on every single invoice. That fine print down at the bottom, or the gray print that's usually on the back side of photocopy, or the we used to call them ditto paper back in the day, but the stuff that's on the obverse side, I would put it on that kind of stuff so that it's everywhere. Because the last thing that you want to do is have the customer think it's fine print. Don't make it fine print. Make it obvious. Make it apparent, so it's not a surprise to them. When nobody likes to be surprised, nobody likes fine print. Nobody likes lawyer language. So don't play a shell game with them. Be very clear about it. Okay, next up, if you're already in business, this is what you want to look at, right? What do these things here have in common? The thing that they have in common is that they are fairly new to business. Look at the little picture here. They didn't exist 10, 12, 15 years ago. So if you've got forms that are that old, look at them, pull them. If you've got a credit application that's that old, pull it and look at it. If you've got any other kinds of forms, pull them and look at them because it could be outdated. Examine the forms or have an attorney look over them for you. Make sure that the forms are collecting the right data that you need. Social security numbers are very, very valuable, particularly if you've got individuals that are acting as personal guarantors on debt or credit. You're going to want to have the social security number, the date of birth. You're going to want to have their bank account information. And we'll go into later exactly why and how that's important. But basically, you want to think about what you're going to need on the back end of the transaction before you get to the back end of the transactions. And then again, to answer the question that we had before, make sure your forms reflect your policy very clearly. A credit application. Again, if you're going to float credit to someone, and many of us do, this is where I would start with your form update, because this is going to be probably your first deep dive with the business health of the person or entity that you're dealing with. You can collect a lot of information about your customer on this credit application. If the business is an LLC, or if it's an Inc. or a LLP, or any of those kinds of business entities, very seriously consider having the principals execute a personal guarantee. But when you do that, make sure that you do it the right way. Again, like I said before, you don't want any surprises. You don't want anybody tricked into being a personal guarantor. You want them coming with their eyes open. So make it conspicuous and have it clearly defined that the individual is being responsible for the billing. I'll tell you a short story about how that blew up on someone. I represented once an elderly lady whose husband went into hospice care. And when she admitted him into hospice, she signed a bunch of paperwork, and he couldn't sign it because he was infirm. And so when she signed everything, she signed it as his attorney in fact, under a power of attorney. And the nursing home, the hospice center, tried to claim that she was a personal guarantor, and they didn't make it conspicuous, and they didn't clearly define that she was signing as a personal guarantor. And I was able to get the entire lawsuit because, let me back up, the husband passed away, sadly, leaving all of that debt on the wife's lap. And she hired me to defend her on the collection lawsuit for that. And I was able to get the court to dismiss the entirety of the debt because the hospice care center did not make the personal guarantee conspicuous or obvious. And so she wasn't aware that she was signing a personal guarantee, and in fact didn't sign a personal guarantee. She only signed as attorney in fact. And so she got out of a debt that was well into 5 figures because she didn't owe it, and they were trying to get her to pay it. So that kind of stuff can be very, very valuable. The next bullet point here, make sure that you have a clause allowing to recover attorney's fees. You definitely want to put that in there too, because if you have to sue somebody, you want to try to get your attorney's fees back. It's very hard to get a court to award attorney's fees. So don't rely too heavily on that being successful. But sometimes it does work. And sometimes we do have success getting that. And when you do have that success, you want to be able to capitalize on that. And then the final point is don't forget to include interest. If people are late in paying and you're floating them credit, you should be paid for that. It's legitimate to be paid for that. It's common to do 1.5% per annum from the date of default, but you got to make sure it's clear and specific, and you got to make sure that it's not too large. There's a body of law called usury, 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 that prohibits inappropriately large interest rates being applied to things. So you don't want to run afoul of those laws. So keep it reasonable in terms of what the market will allow. All right. So next, part two, during the customer relationship, what happens? Well, one of the problems that we all have is, let's say you have a big account and they're just not paying. That's frustrating. That's a real strain on your business because it makes you cash poor. You need that liquidity to pay payroll, to pay your vendors, to pay your utilities, all of those things. So how do you tell your customer that they're past due without upsetting them and making them pull all of their business or do whatever? This is why it's so important to set the expectation up front, because you can rely on your policy and say, hey, look, I told you this when you signed up, that this is the policy and this is the policy. And a reasonable person on the other side of that will say, yeah, I know. I remember we had that conversation when I signed up. I remember reading that in the contract. I remember seeing it on the invoice. I'm sorry. Let me see. Let's try and work something out. And they're going to be more reasonable. And you're going to have an easier time trying to get them to work it out. If they get all sanctimonious about it and, they're saying, well, it's a stupid policy, blah, 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 then you probably don't want to be doing business with them anyway. And you probably should start thinking about how you're going to offboard them at some point in time. Because, a lot of times the success of your business isn't just how many customers you have, but what the quality of the customers are. And you can offboard C, D, F rated customers and service the A, B, and C rated ones that actually pay you, so that when you're doing work, when you're providing goods and services, that you're getting paid for that. And how do you let them know? Well, you gotta let them know politely but firmly that they're past due and they owe you money. The last thing you want to do is be Shylock from the Merchant of Venice showing up wanting your pound of flesh, right? And you can work with a lawyer to craft a diplomatically worded letter that you can use as a form letter to send out in those cases where you need to notify someone that they're past due and that you're requesting payment without upsetting them. The other thing that you want to do is you want to get rid of bad debt, right? If you've got a customer that's not paying you and they haven't been paying you for a while, do whatever you can to get that debt off your books. The longer you wait, the more likely it is that you're not going to get paid. Look at this statistic. The chances of not getting paid increase by more than 1% a week after the past due date. And the recoverability drops below 50% after 6 months and 25% after 12 months. So think about that, right? If you've got debt that's been on your books for a year, you got less than a 25% chance of ever seeing a dollar of that. And that's why you see people making deals for 50 cents on the dollar, 30 cents on the dollar, or more to the point, you see people selling their debt to other people in the industry. And these are the types of people that I see in my comings and goings. They're called debt buyers. And what they'll do is they'll buy entire portfolios of bad debt knowing that they're not going to collect on most of it and hoping that they're going to collect on a percentage of it that will offset what they buy it for. So you can either try to resolve it yourself with your customer, or you could consider getting a professional involved. There are different types of professionals that you can get involved. Like I said, you can use a debt buyer, you could use a debt collection agency, or you could go straight to an attorney. Attorneys take these kinds of cases generally on contingency fee. That means that they don't get paid unless you get paid. They take a percentage of what they recover for you. Generally speaking, that's a third. Sometimes it's much as 40%. But if you've got volume, if you're giving this attorney more than one or two or three cases, let's say you have a whole portfolio of 20 or 30 or 40 accounts, you've got a little bit more leverage to negotiate that rate down to 30%, 28%, 25%, maybe even as far as 20% contingency fee if you've got enough business to give the attorney and it looks like it's collectible. And usually collectability means that the entity has some assets that we can attach, or there are personal guarantors who have assets that can be attached, or they have another source of income or a bank account or something like that that can be garnished. Keep in mind that you might not, when you chase this bad debt, the chances of you getting paid 100% are very, very slim. And like I said in the last slide, they get slimmer as you go along. So you have to resign yourself to the fact that once this debt is bad debt, you're not getting 100% of it back, which is why you don't want to get it there in the first place. And that's why you set up stuff the way you set it up at the beginning. But the reason that you want to use a professional for doing this rather than doing it yourself is severalfold. One, because we know what we're doing, and we can do it a lot faster and a lot more efficiently than you can do it yourself. Also, professionals in the industry are highly regulated. You have the Consumer Finance Protection Board, the CFPB, which regulates consumer debt very heavily. And you've got organizations like the BBB that monitor businesses for trustworthiness in the community. And you don't necessarily have those assets at your fingertips if you're trying to do this on your own. And most importantly, it gives you the ability to handle your business rather than chasing money. Yeah, you've ever heard the phrase of throwing good money after bad, right? That's what you're doing if you're not realizing the time value of your own time, right? And the dollar value that equates to. And, whenever people ask me, why should I hire an attorney to do this when I can do it myself? I always give them this kind of an analogy. If you had a toothache or a tooth that had a cavity and needed to come out, it's very, very painful. You could, of course, go into your tool shed, grab a pair of pliers, wrap that thing around that tooth and yank that right out of there. And most likely you'll probably get it out. It'll probably hurt a little bit. It will most certainly bleed. But it's not going to be the best way to get that done. You would much rather go to a dentist and get that done, right? I mean, I think that most of us would think that it's silly to try to yank our own tooth out with a pair of pliers. Self-help in the legal industry, particularly if you're going to try to wade into the court system, is very, very dangerous like that, particularly now in the post-COVID world. because when COVID happened and we all got locked down, courts shut down completely. And what happened was a lot of companies that had outstanding receivables or that were professionals in this industry like me were told or chose to stand down and not collect against people that owed them money. And so a lot of people, because people were losing their jobs and things like that, nobody again, no one wanted to be, the Shylock knocking on someone's door when they're on a ventilator saying, oh, by the way, you didn't pay your bill last month. Nobody wanted to be that guy. And so a tremendous amount of debt just stalled. It just sat there for 2 years. And now it's starting to move again. And there's a lot of it. And the court system is absolutely inundated with this kind of stuff. And if you try to navigate that yourself without somebody on the boat who knows how to get through those choppy waters, you're gonna spin your wheels quite a bit, and you're gonna be very, very frustrated. And it's going to be very, very time consuming for you. So consider using a professional. Part 3. So what happens when you've tried, and you're like, you know what? I think I'm kind of done here. I need help. What can you do? Well, here's some of the tools that we have in our tool bag. The first one is a wage garnishment. Wage garnishment is the easiest way to get paid if you know your debtor has a job that they're trying to protect, a job that they don't want to lose, right? So you file something called a writ of garnishment of wages, and you file that with the court. It's a very simple form to file. It's very inexpensive to file. And then what happens is that gets served on the employer, and then the employer has a legal obligation to withhold a percentage of that person's paycheck and turn it over to you to pay that debt. In most jurisdictions, the law will allow you to go for up to 25% of the net pay to be withheld from the paycheck. Now, that varies from state to state, and there's some other things that go into that in terms of what you're allowed to do and what you're not allowed to do. But just generally speaking, a wage garnishment is a very, very effective tool to try to get you paid. Now, you remember when I told you, you want to have a wage garnishment, or you want to have a personal guarantor. This is where that comes in. Right? Because if you have a person whose business, let's say that business is not their full-time business, is a side hustle for them, and they have a job outside of that business, then they want to protect that primary income. They're going to want to, get you paid rather than losing their job. If the person who's the personal guarantor is working within the business that's your customer, they still have to pay themselves something. And so if you file a wage garnishment, they're not allowed to take a salary without paying you also. So, you're sort of getting them coming and going. Now, the trick that some of them try to do in that circumstance is to just not take a salary. And if they don't take a salary, they're not getting off the hook, because you've got this tool in your utility belt too, the garnishment other than wages. So what is this? This is a garnishment of things other than a paycheck, other kinds of assets or liquidity that they've got. What are some things that would qualify for this? The easiest one is a bank account. Every business has to have a bank account somewhere. Nobody is working 100% on cash. And so if you can find out where they bank, remember back when we were talking about the credit application and looking for bank references and things like that, now all of a sudden you've got the information about where they bank. So you can file a garnishment other than wages, and you can attach their bank account and withdraw money from their bank account to pay your debt. Very, very convenient. And the bank, if it has assets in the name of the debtor, has a legal obligation to pay you the money that they have on hand. And if the bank doesn't pay that to you, then the bank becomes the debtor. And then you can collect from the bank. And we all know how deep pockets are for banks. So they have a vested interest in making sure that you get paid what you're owed if they have it on hand. Now, some debtors get very, very tricky about this, and they spread their banking out. And they might tell you about one bank account that they have, and they may use two or three other banks. So you don't have to just use the bank they tell you about. You can cast a wider net. And one of the things that I like to do is I use Google Maps, and I'll pull up Google Maps and I'll map out where the person lives and where the business is located. And I will map out directions between those two locations. I'll have it put right on the thing. And then I will do a search within that quadrant of all financial institutions, all banks. And I'll send a garnishment to every single one of them. And if there's no one there, then there's no one there. But chances are these folks are going to be banking somewhere close to where they live or where they work. And if they've got a hidden bank account, they're not going to be that clever about it where you can cast that wide net and catch them. What are some other ways that you can try to get at assets? Some other creative ideas is a credit card processor, right? If somebody's got if they take credit cards in their business, find out who does their credit card processing. Again, that could be something that you can ask for on the front end on the credit app. Get that credit card processor and send a garnishment to them so that when their credit card receipts come in for a given day, week, month, or whatever it is, you'll attach that and get paid by that credit card processor. Another one is a cash register, a physical cash register. I had a colleague of mine that filed a writ of garnishment on a cash register for a restaurant once and walked into the restaurant and opened the register drawer and literally physically took the cash out of it and was legally entitled to do so. Now, there are things that you have to do in order to make that happen. You have to have a sheriff come with you. You're not allowed to breach the peace and things like that. So there are hoops that you have to jump through, but it can be done. PayPal and Venmo accounts. If folks have those, you can garnish those accounts as well. A lot of people keep balances in those accounts and they don't shift them into their bank accounts. You can also send them subpoenas and find out if they are shifting them to bank accounts, what bank accounts are they shifting them to? And boom, you've got another bank account that you can try to garnish. Anything else that you can try. And if you get a judgment against them, you could do a sheriff's sale, because if you file a lawsuit against them, you get a money judgment. A money judgment becomes a lien against any real property that they have in the county in which the judgment was entered. And if they have real property in another county or even in another state, you can have that judgment transferred over and enrolled locally there and then try to attach that. And you can do that for real estate, real property, or you can also do it for personal property too. So you can try to attach vehicles, you could try to attach business equipment, anything else that might have value. An attorney can work through trying to get those assets. I've attached all kinds of crazy things. I even attached someone's boat once in Florida. A guy had a really, really nice yacht down in Florida, and he had it docked and thought it was safe because he was doing business in Maryland, and he had this boat in Florida. But little did he know that I was able to take the judgment and roll it down in Dade County, which is near Miami. And then I hired local counsel down there to do something that's called arresting a boat. Arresting a boat is like repossessing a car. And there's a very specific process that you have to go to arrest the boat. We were able to arrest his boat, and he panicked and then paid us because he didn't want to lose his boat. So when you put that kind of pressure on people, all of a sudden they find money that they couldn't otherwise find.
Hey, Bill, I have a question.
Sure.
Do all these tactics, tools in the toolbox apply? Because I know a lot of our folks, their customers are individuals, they're not businesses. So do they apply to individuals as well as businesses when you're going after them?
They do. They
Okay.
do. And that's why it's so important to, even if you're talking about a business, to get a personal guarantor, because it's really easy to lean on a person, or it's easier to lean on a person to get paid than it is to lean on a business, right? Because businesses are able to declare bankruptcy or just shut down the business, and then they reopen another business exactly like the business they were doing before. And then you have to try to unwind that transaction. And all of that can be done. It's just more time consuming, it's more complicated, and it's more expensive. But if you can lean on the person, particularly with the wage garnishment, because people want to protect their jobs, occasionally you'll get the job hoppy person that doesn't really care about their job, and they will quit a job, and then they'll get another job. And then when you find that job, they'll quit that job, and you're constantly chasing them. Eventually, you're going to catch them. So, yeah. Okay, so going on then to liens and attachment, because you heard me mention the word lien before. So what does that mean? So a lien is just a legal term of art for a security interest against a piece of property. It's basically what creates collateral, right? So when you have a lien against something, picture your mortgage, right? When you buy your mortgage it creates a lien on your house, so that if you don't pay your mortgage, the person who gave you the money to buy your house is able to come in and sell your house in order to pay off the debt that they gave you, the money that they gave you to buy your house. Another common lien is your car note, right? When you buy a car, there's a security interest. When you get that blue title, you'll see on the bottom of the title, there's a lien for, Ford Motor Credit or Toyota Motor Credit or whoever you got your loan through. And then you'll get the red copy of the car title. When you pay that off, it'll say there are no liens or security interest on the vehicle, and that's when you own it outright. So what is a lien attached to? It'll attach to whatever collateral the contract says. It also, if it comes from a judge, this is what we call a judgment lien, which is when you sue someone for a debt they owe and you get a money judgment, and that becomes a judgment lien against any real property that they own in the county. And then you can also have it transferred to county, as I said before, or state to state. How long does that lien stay in place? That depends on the state. For example, in Maryland, it stays in place for 21 years, and it's renewable for another 21. In Virginia, it's significantly less. I think it's 12 years in Virginia, and then it's renewable for another 12. Or maybe that's vice versa. I think it's 12 years in Maryland, 21 in Virginia. Anyway, it depends on which state that you're in. And the way that you get paid from that is effectively like a foreclosure. You file something with the court asking to enforce the lien, and the court will appoint a sheriff to take whatever property there is into custody and then sell it by auction. And you've seen these probably outside of the courthouse, or you've seen these in auction companies. They'll just sell it off to the highest bidder, and then whatever money they can get for it, they'll pay you on that. So the next tool in our toolbox is oral examination. So the other thing that you can do is, if you get a judgment against someone, a money judgment, you can ask the court to compel them to come into court and answer more questions about what their finances are, what their assets are. And they have to do it under oath. And this is a really, really good tool, because if they don't answer under oath, you can ask the judge to hold them in contempt. And under the powers of contempt, the judge can put them in jail until they answer. And if they don't show up, you can ask the judge to first get for a show cause, making them come and show why they didn't show up the first time. And then secondly, you can ask the judge to send a sheriff out to pick them up and arrest them and forcibly bring them in to answer the questions that you want to have them answer. It's a very powerful tool to be able to have someone who's ducking you come in and be accountable for what their finances are. And so with that, I think that kind of brings us to the end of our toolbox and really to the end of our presentation. So as you can see, you've got 3 different phases, and you want to be thinking about each separate phase and what you can do as a business owner to minimize and collect as much information as you can. So if it gets sideways, if it goes into arrears, you have as much information and as much power to try to get paid as you can. With that, I'm open to questions if anybody has any.
No, I think
Yes.
we can. Oh, here we go.
Yes, I have a question. Hi, this is Zandria or Z. Um, what kind of information can you not ask for, like on a contract? Now I know, like with the law, the certain government, like you can't ask personal about your kids and all that, their sex and those type of things. But when it comes to the business, like you said, you can ask the social security, the birth date, and banking information. Can you go deeper into asking like for collateral?
You can ask for collateral, but you have to be prepared with the proper documentation to show why you need that collateral. If you're going to extend credit to someone and you're utilizing that collateral as a security interest, there are certain things that you need to do under the Uniform Commercial Code, that if you're going to go that deep on it, you would absolutely want to hire an attorney to help you set that up. Going into the Uniform Commercial Code is not something that you want to try to do yourself under Article 2, Article 3. Like there are a lot of minefields in that code. It's probably in all of my legal career, it's probably the second most complicated code that I've seen behind the tax code, in terms of regulating what you can and cannot do, or what you should and should not do, what your paperwork should and should not say. So if you're going to go that deep, have an attorney go that deep for you on the front end. But in terms of just general business, I think that the information you want to ask for stuff that's related to the transaction that you're doing. You don't want to ask, who their kids are, and what their ages, what their dates of birth are. Like some of that's just not relevant. So you want to be able to not pry into people's privacy, because it's going to turn them off as a customer. And quite frankly, if you get on the back end of that transaction and it's sideways and you need that information, I can find it. I can get it for you. I pay for services that can track down that kind of information. So you don't want to risk the customer relationship on the front end by going too deep into personal stuff like that, private stuff like that.
If I could follow up if there's no other questions, because I know
Sure.
we're on a time.
Sure. Go
So
ahead.
you mentioned taxes, and I do have a tax business. So the questions that you would ask, would it be on it's pertaining to what type of business you have? Like some questions you can't ask because I got a tax business, some
Right.
questions you can ask because you have a medical
Right.
in that
Right.
field related. That's what are the questions field related in the universal code or not? It's very broad
They're
and
not. Those fields have their own specific areas, like the medical field has its HIPAA regulations,
okay.
and right, and the tax field has its, as you're surely familiar, the tax code in terms of what you're allowed to do and look at. So yeah, if you're going to go that deep, again, have a professional look at that for you.
Okay. Great. Thank you.
Yeah, you bet. Anybody else have any questions?
Think you were too thorough, Bill.
Well, that's not a bad thing, I suppose. Well, okay. Well, hearing none, then I want to thank everybody for taking an hour or so out of your day today to listen to me. And everybody, please have a wonderful weekend. Hold on, we got one question. We got a raised hand here at the
Yeah,
end.
Bill.
Go ahead.
Sorry about that.
No, go ahead.
How do we get like a list of references of attorneys within the area if we do fall into a situation where we need one?
You can go there are a bunch of lawyer referral services, and if you just Google, lawyer referral near me, it'll come up. The Maryland State Bar Association will have information like that as well. That's probably where I would start, would be the MSBA. And then you can also go on to the state of Maryland's, like the Maryland State Bar, which is different than the Bar Association. And they'll have a list of attorneys too. And really, you can just Google, what kind of attorney you're looking for, and it'll pop up in your Google search.
And
Just,
that's my
make
next.
sure you do your due diligence on those folks too, and, know who you're talking to and what you're paying for and how much you're paying and all those kinds of things. Not saying that, attorneys can be flim-flammy or anything, but whenever you're doing business with anybody, you should always make sure that you dot your I's and cross your T's.
And that would be my next follow-up question to that. What type of attorney then will we be trying to seek for
Well,
this type of?
it depends on what you're trying to do. But if you're talking about somebody who does what we're talking about specifically in this,
Yes.
I would say you want a collection attorney, someone
So
who does debt collection or creditors' rights. Those are the words that you're really looking for. And you have to also be aware that there's a difference in commercial collection versus consumer collection. And so if you're trying to collect debt that's owed to your business, you should want to know the difference between consumer collection and commercial collection. Commercial collection is B2B, business to business. So if you have a vendor that hasn't paid you, you want commercial collection. If it's, B2C, consumer to business, you're going to want a consumer collection attorney. And the reason that distinction is important is because there's something called the Fair Debt Collection Practices Act, which regulates I could do a whole 3-hour lecture on the FDCPA, but that regulates consumer debt, and consumer debt is regulated very heavily, much more heavily than commercial debt is. So you want to make sure that you're playing in the right ballpark when you do that.
All right. Thank you very much, sir.
Yeah, you bet. Anybody else? Okay, great. Listen, everybody, thank you again for being here.